Section 42. Legal nature of shares. 1. The shares of a member in a company are movable property. 2. The number of shares in a company and the rights and liabilities attaching to the shares are dependent on the terms of issue. Section 43. No par value shares. The shares created or issued under this Act are shares of no par value. Section 44. Issue of shares. 1. Subject to the registered constitution of a company, different classes of shares may be issued in a company at the times and for the consideration that the company shall determine and shall be paid for, at the times that are agreed between the member and the company. 2. On the winding up of the company, every past and present shareholder of the company is liable to contribute to the assets of the company to the extent referred to in Section 40. Section 45. Payment of shares. 1. Except on a capitalization issue pursuant to subsection 1 of Section 77, shares shall not be issued otherwise than for valuable consideration paid or payable to the company, and unless otherwise agreed, shares shall be paid for in cash. 2. Where a company agrees to accept payment for shares otherwise than wholly in cash, the company shall, within 28 days after the allotment of the shares, deliver to the registrar for registration a contract in writing duly stamped evidencing the terms of the agreement and the true value of the consideration, or, if the agreement has not been reduced to writing, particulars in the prescribed form of the agreement duly stamped, as if it were a written agreement. 3. The particulars referred to in subsection 2 shall not be required on a capitalization issue of shares pursuant to subsection 1 of Section 77. 4. The statement in the agreement of the value of the non-cash consideration is sufficient evidence of the true value of the consideration, but when a company limited by shares is in the course of being wound up under the body's Corporate Official Liquidations Act, 1963, Act 180, the liquidator or a creditor may apply to the court, and if the court is satisfied that the true value of the consideration was less than stated, it may direct that the shares shall be treated as unpaid to the amount of money that it shall direct. Section 46. Return of issues. Where a company issues shares, other than a reissue of treasury shares as defined in subsection 3 of Section 61, the company shall, within 28 days after the issue, deliver to the registrar for registration a return in the prescribed form showing, as at the date of the return, a. the amount of the stated capital, attributable to each of the items specified in subsection 1 of Section 68, b. the number of the authorized shares of each class. c. the total number of the issued shares of each class and the amount of money paid on the shares, distinguishing between the amount paid in cash and the amount paid otherwise than in cash, and, in the case of a company limited by shares, the amount of money remaining payable on the shares, distinguishing between the amount presently due for payment and the amount not yet due for payment, and d. the total number of the treasury shares of each class. Skip Section 47. Section 48. Meaning of payment in cash. 1. For the purposes of this Act, shares have not been paid for in cash except to the extent that the company has actually received cash for the shares at the time of, or subsequent to the agreement to issue the shares. 2. Where shares are issued to a person who has sold or agreed to sell property or rendered or agreed to render services to the company or to persons nominated by that person, the amount of money of a payment made for the property or services shall be deducted from the amount of a cash payment made for the shares, and only the balance shall be treated as having been paid in cash for the shares despite an exchange of checks or any other securities for money. Section 49. Classification of shares. 1. The registered constitution of a company may provide for different classes of shares by attaching to certain of the shares preferred, deferred, or any other special rights or restrictions, whether as regards dividend, voting, repayment, or otherwise. 2. Shares are not of the same class unless they rank at the same rate for all purposes. Section 50. Variation of class rights. 1. Where at any time the shares of a company are divided into different classes, the rights attached to a class shall not be varied unless otherwise expressly provided for in the constitution of a company. 2. Where the constitution of a company expressly forbids a variation of the rights of a class, or contains provisions regarding that variation and expressly forbids an amendment of the provision, in respect of the variation of rights, The rights shall not be varied and the provision for variation shall not be amended except with the sanction of the court under a scheme of arrangement in accordance with Section 239. 3. Except as provided in subsection 2, a company may, by special resolution, amend its constitution by inserting in the constitution provisions regarding the variation of the rights of a class, or by modifying the terms of those provisions. 4. An amendment under this section requires the prior written consent of the holders of at least 3/4 of the issued shares of each class or the sanction of a special resolution of the holders of the shares of each class and shall be deemed to be a variation of the rights of each class. 5. Despite a provision in the constitution of a company to the contrary, the rights attached to a class of shares shall not be varied except with the written consent of the holders of at least 3/4 of the issued shares of that class, or the sanction of a special resolution of the holders of the shares of that class. 6. A resolution of a company the implementation of which would have the effect of a. Diminishing the proportion of the total vote exercisable at a general meeting of the company by the holders of the existing shares of a class, or b. Reducing the proportion of the dividends or distributions payable at any time to the holders of the existing shares of a class, is for the purposes of this Act, a variation of the rights of that class. Section 51, Preference and Equity Shares. 1. In this Act, preference share means a share, which does not entitle the holder of the share to a right to participate beyond a specified amount of money in a distribution whether by way of dividend, on redemption, in a winding up, or otherwise, and any other share shall be referred to as an equity share. 2. A share that is not a preference share shall be referred to as an equity share. 3. The meaning of preference share under subsection 1 shall apply to whatever name a company may designate in its constitution. Section 52, Suspension of voting rights of preference shares. 1. Despite Section 34, the right of holders of preference shares to attend and vote at a general meeting of the company may be suspended on conditions. 2. Despite a provision to the contrary in the constitution of a company, preference shares carry the right to attend general meetings and on a poll at those meetings to at least one vote per share in the following circumstances, but not otherwise. A. On a resolution during the period that the preferential dividend or a part of the preferential dividend remains in arrears and unpaid, the period starting from a date not more than 12 months, or a lesser period that the constitution of a company may provide, after the due date of the dividend. B. On a resolution which varies the rights attached to those shares. C. On a resolution to remove an auditor of the company or to appoint another person in place of that auditor, or D. On a resolution for the winding up of the company or during the winding up of the company. 3. Apart from the circumstances in Section 34 and subject to subsections 1 and 2 of this section, preference shares carry the right on a poll at a general meeting of the company to one vote, only, in respect of each share. 4. A special resolution of a company increasing the number of shares of a class may validly resolve that an existing class of preference shares shall carry the right to the vote specified in subsection 3, additional to one vote per share as shall be necessary in order to preserve the existing ratio which the votes exercisable by the holders of those preference shares at a general meeting of the company bear to the total vote exercisable at the meeting. 5. For the purposes of subsection 2, a dividend is due, a. on the day immediately following the expiration of the year or other period, or b. where a company has a registered constitution, on the date appointed in the constitution for the payment of the dividend for a year or other period whether or not the dividend has been earned or declared. Section 53, Votes of Equity Shares. 1. Despite a provision to the contrary in the constitution of a company, equity shares carry the right on a poll at a general meeting of the company to one vote only, in respect of each share subject to Section 34. 2. For the purposes of subsection 1, an alteration of the rights of issued preference shares so that they become equity shares is an issue of equity shares. Section 54, Canons of Construction of Class Rights. In construing the provisions of the constitution of a company in respect of the rights attached to shares, the following canons of construction shall be observed. A. Unless the contrary intention appears, a dividend is not payable on any shares unless the company resolves to declare that dividend. B. Unless the contrary intention appears, a fixed preferential dividend payable on a class of shares shall be cumulative. In other words, a dividend is not payable on any shares ranking subsequent to that class of shares until all the arrears of the fixed dividend have been paid. C. Unless the contrary intention appears, in a winding up, arrears of a cumulative preferential dividend whether or not earned or declared is payable up to the date of actual payment in the winding up. D. If a class of shares is expressed to have a right to a preferential dividend, then, unless the contrary intention appears, that class does not have a further right to participate in dividends. E. If a class of shares is expressed to have preferential rights to payment out of the assets of the company in the event of winding up, unless the contrary intention appears, that class does not have a further right to participate in the distribution of assets in the winding up. F. In determining the rights of the various classes to share in the distribution of the property of the company on a winding up, consideration shall not be given unless the contrary intention appears, to whether or not the property represents accumulated profits or surplus which would have been available for dividend while the company remained a going concern, and G. Subject to this section the shares rank equally in all respects unless the contrary intention appears. Section 55, Issue of Share Certificates. 1. Subject to the Central Securities Depository Act, 2007, Act 733, a company shall, within 2 months after the issue of any of the shares of the company or after the registration of the transfer of a share, deliver to the registered holder of the share, a certificate certified by one director and the company secretary indicating A. The number and class of shares held by that holder and the definitive numbers of the shares. B. The amount of money paid on the shares and the amount remaining unpaid, and C. The name and address of the registered holder. 2. Where a share certificate is defaced, lost or destroyed, the company at the request of the registered holder of the shares, shall renew the certificate on payment of a fee prescribed by the company and on the terms as to evidence and indemnity and the payment of the out-of-pocket expenses of company of investigating evidence that the company may reasonably require. 3. Where a company defaults in complying with this section, the company and an officer of the company who is in default are liable to pay to the registrar an administrative penalty of 50 penalty units. 4. Where an application is made to the court by a person entitled to have the certificate delivered to that person, the court may order the company to deliver the certificate and may require the company and that officer to bear the cost of and incidentals to the application. Section 56. Effect of share certificates. 1. Statements made in a share certificate under the common seal of the company or are certified by 2 directors and the company secretary of the company, are prima facie evidence of the title to the shares of the person named in the certificate as the registered holder and of the amounts of money paid and payable on the certificate. 2. Where a person changes a position to the detriment of that person in reliance in good faith on the continued accuracy of the statements made in the certificate, the company is estopped in favor of that person from denying the continued accuracy of those statements and shall compensate that person for the loss suffered by that person in reliance on those statements and which that person would not have suffered by the statement being or continue to be accurate. 3. Subsections 1 and 2 do not affect the right the company may have to be indemnified by any other person. 4. The provisions of subsections 1, 2, or 3 do not apply in the case of shares which can be transferred through a scheme of a central depository under the Central Securities Depository Act, 2007, Act 733, or any other relevant enactment. Section 57, Reserve Liability. 1. A company limited by shares may, by special resolution, determine that a portion of the unpaid liability on its shares which has not already been called up shall not be capable of being called up except in the event, and for the purpose, of the company being wound up. 2. Where resolution is passed, that portion shall not be capable of being called up except in the event and for the purpose stated in that subsection. Section 58, Prohibited Transactions in Shares. 1. Except as provided in this Act, a company shall not a. Alter the number of its shares or the amount of money remaining payable on those shares. B. Release a shareholder or former shareholder from a liability on the shares. C. Provide financial assistance, directly or indirectly, for the subscription or purchase of the shares of the company or the shares of its holding company, or D. Acquire, by way of purchase or otherwise, any of its issued shares or any shares of its holding company. 2. For the purposes of paragraph D of subsection 1, shares are acquired by the company if they purport to be held in trust for the company although they are registered in the names of nominees. 3. Subsection 1 does not prohibit a company from voluntarily acquiring its own shares on the conversion of the company to a company limited by guarantee in accordance with Section 9. 4. In the event of a breach of this section. A. If the breach is of paragraph A or B of subsection 1, the purported alteration or release is void and every officer of the company who is in default is liable to pay to the registrar an administrative penalty of 500 penalty units. B. If the breach is of paragraph C or D of subsection 1, then 1. Knowledge of the breach, voidable by the company, and a payment made by the company in respect of that transaction is immediately repayable with interest at the yearly interest rate applicable to the 91-day government treasury bill or a higher rate that the court may order, and 2. Whether or not the transaction is avoided, every officer of the company who is in default is liable to pay to the registrar an administrative penalty of 500 penalty units or twice the amount of money of a provision or payment made by the company in respect of the transaction, whichever is the greater. Section 59. Alteration of number of shares. 1. Subject to subsection 3, a company may A. Increase the number of the shares of the company by creating new shares, or B. Reduce the number of the shares of the company by cancelling shares which have not been taken or agreed to be taken by a person or by consolidating its existing shares, whether issued or not, into a smaller number of shares. 2. On a consolidation of shares. A. The amount of money paid. B. An unpaid liability on the shares, and C. A fixed sum of money by way of dividend or repayment to which the shares were entitled shall also be consolidated. 3. Unless otherwise provided in the constitution of a company, the directors may issue shares with rights or restrictions as may be determined by the directors, subject to the provisions of this Act. Section 60. Financial assistance for acquisition of shares. Section 58 does not prohibit any of the following transactions. A. The payment or commission or brokerage to a person in consideration of that person subscribing or agreeing to subscribe or procuring or agreeing to procure subscriptions for any shares in the company, where the payment of commission or brokerage does not exceed 10% of the price at which the shares are issued or a lesser rate as may be specified in the constitution of the company. B. Where the lending of money is part of the ordinary business of the company, or lending of money is the ordinary course of business although the money may be used for the subscription or purchase of shares in the company or its holding company. C. The provision by a company of money for the purchase or subscription of shares to be held for the benefit of persons genuinely in the employment of the company or an associated company including a director holding a salaried employment in the company or an associated company in accordance with a scheme for the time being in force. D. The advancing by a company of loans to persons, other than directors, genuinely in the employment of the company or an associated company with a view to enabling those persons to purchase or subscribe for shares to be held by themselves beneficially and not as nominees for the company or any other person. E. The payment by a company of a lawful dividend on the shares of the company although the dividend received by a shareholder is used to discharge a liability on the shares of that shareholder or to repay money borrowed for the purpose of subscribing or purchasing shares. F. In the case of a public company some or all of whose equity shares are dealt with on an approved stock exchange, or in respect of which an application has been made to an approved stock exchange for permission to deal in those shares, the payment of any commissions, fees, costs and expenses and the giving of any indemnities and warranties in each case to a person arranging or otherwise involved in an underwriting, placing or sale of securities in the company or any other similar transaction. Where an application for permission to deal in those securities has been or is to be made to an approved stock exchange. And 2. Any other financial assistance is given in good faith in the interest of the company. Section 61, Acquisition by company of its own shares. 1. Despite Section 58, a company may a. Create and issue preference shares which are, or at the option of the company are liable, to be redeemed and may convert existing shares, whether issued or not, into those redeemable preference shares subject to Section 62 to 65. B. Purchase its own shares subject to Section 63 to 67. C. Acquire its own shares by a voluntary transfer to the company or to nominees for the company subject to compliance with Section 62 to 65, and D. Acquire its own shares pursuant to the buyout provisions in Section 222. 2. For the purposes of subsection 1, shares shall not be redeemed, purchased or acquired by the company so long as there is an unpaid liability on those shares. 3. A company may forfeit the shares issued with an unpaid liability for non-payment of the sums of money due and payable on those shares. 4. On redemption, purchase, acquisition or forfeiture, shares shall be available for reissue by the company unless a company by amendment of the constitution of the company cancels those shares. 5. Shares which are cancelled by virtue of the constitution of the company, shall until reissued or cancelled, be referred to as treasury shares. 6. Except as provided in Section 69, a redemption, purchase, an acquisition or a forfeiture by the company of the shares of the company, or the cancellation of shares so redeemed, purchased, acquired or forfeited shall not reduce the stated capital of the company. 7. Voting rights shall not be exercised and dividends shall not be payable on treasury shares, and except where otherwise stated, treasury shares shall not be treated as issued shares within the meaning of this Act. Section 62, Redemption of redeemable preference shares. 1. Despite a provision in the constitution of the company to the contrary, a company shall not redeem any of its redeemable preference shares except a. Out of a credit balance on the share deals account referred to in Section 65 or out of transfers to that account in the manner referred to in that section from retained earnings as defined in Section 71. Or b. Out of the proceeds of a fresh issue of shares made for the purposes of the redemption not more than 12 months before the date of redemption. 2. Where redeemable preference shares have become redeemable and the funds of the company are sufficient to entitle the company to redeem the whole of the shares due for redemption, the holder of those shares may serve notice on the company requiring it to effect the redemption. 3. Where the company fails to redeem the shares within 28 days of the service of the notice, the shareholder who has served the notice may apply to the court on behalf of that shareholder and the other shareholders whose shares are due for redemption, and the court, if satisfied that the conditions of this subsection are fulfilled, may order the company to redeem the shares and may require the company and an officer of the company who is in default to bear the cost of, and incidental to, the application. 4. Section 205 shall apply to an application to the court under subsection 3. Section 63, Purchase by a company of its own shares. Despite a provision of the constitution of the company to the contrary, a company shall not purchase any of the shares of the company except where a. Shares are only purchased out of a credit balance on the share deals account referred to in Section 65, or out of transfers to that account in the manner referred to in that section from retained earnings. b. Redeemable preference shares are not purchased at a price greater than the lowest price at which they are then redeemable or will be redeemable at the next date at which they are due or liable to be redeemed, or c. The purchase is not made in breach of Section 64. Section 64, Limit on number of shares acquired. 1. A transaction shall not be entered into by or on behalf of a company by which the total number of its shares, or of its shares of any one class, held by persons other than the company or its nominees becomes less than 85% of the total number of shares, or of shares of that class, which have been issued. 2. For the purposes of subsection 1, redeemable preference shares shall be disregarded. 3. Where, after shares of a class have been issued and the number of those shares has been reduced, subsection 1 shall apply as if the number originally issued, including shares of the class cancelled before the reduction took effect, had been the number as so reduced. Section 65, Share Deals Account. 1. When a company first redeems or purchases any of its shares, otherwise than on a redemption of redeemable preference shares out of the proceeds of a fresh issue of shares in accordance with paragraph B of subsection 1 of section 62. It shall open a share deals account and shall credit to that account a sum of money not less than the amount of money to be expended on the redemption or purchase by transferring that sum from retained earnings as defined in section 71. 2. There shall be debited to the share deals account the sums of money which the company shall from time to time expend on the redemption or purchase of any of the shares of the company, otherwise than on a redemption of redeemable preference shares out of the proceeds of a fresh issue of shares in accordance with paragraph B of subsection 1 of section 62. 3. The net price or the value of the consideration received by the company on the reissue of any of the treasury shares of the company shall be credited to the share deals account. 4. If at any time the total amount of money to be debited to the share deals account under subsection 2 exceeds the amount of money credited to that account in accordance with subsections 1, 2, and 3, an amount of money equal to the excess shall be transferred to the credit of that account from retained earnings, and a purchase or redemption, otherwise than a redemption of redeemable preference shares out of the proceeds of a fresh issue of shares in accordance with paragraph B of subsection 1 of section 62, shall not be made by the company unless its retained earnings is sufficient to enable the transfer to be made. 5. An amount of money shall not be debited or credited to the share deals account, otherwise than in accordance with subsections 1, 2, 3, and 4, except on a transfer to stated capital in accordance with section 68 or under an order of the court under section 80 or 239. 6. A true copy of the share deals account, showing the class and number of shares involved in each transaction and the price paid or received for those shares, shall be kept in a separate book at the registered office of the company and shall during business hours be open to the inspection of a member without charge and of any other person on payment of a fee prescribed by the company for each inspection unless otherwise subject to reasonable restrictions expressed in the constitution of a company. 7. Not less than 2 hours in each day, other than a Saturday, Sunday, or a public holiday shall be allowed for the inspection. 8. A member or any other person is entitled to be furnished, within 10 days after the member or that person has made a request in that behalf to the company, with a copy of the share deals account or a part of the share deals account at a fee prescribed by the company. 9. Where an inspection required under subsection 6 is refused, or where a copy required to be sent under subsection 8 is not sent within the proper time, the company and every officer of the company who is in default is liable to pay to the registrar an administrative penalty of 25 penalty units for each day during which the default continues, and the court may order an immediate inspection or furnishing of a copy. Skip section 66. Section 67, Acquisition of shares of holding company. 1. Despite section 58, a company which is a subsidiary may acquire shares in its holding company, where the subsidiary company is concerned as a personal representative or trustee unless the holding company or a subsidiary of the holding company is beneficially interested otherwise than by way of security for the purposes of a transaction entered into by the holding company or subsidiary of the holding company in the ordinary course of a business which includes the lending of money. 2. A subsidiary which is a holder of shares of its holding company or a subsidiary which acquired shares in its holding company before it became a subsidiary of that holding company may continue to hold those shares but, subject to subsection 1, shall not have a right to vote at meetings of the holding company or a class of shareholders of the holding company, and shall not acquire any future shares in the holding company, except on a capitalization issue in accordance with subsection 1 of Section 77.